Is a worker an independent contractor or employee? This is an often asked question due to the significance the answer has on both employers and employees. Employers like to have independent contractors because it saves them money and reduces their possible legal liability. Workers prefer to be employees because it increases their legal rights and the benefits they are eligible for. For example, the Fair Labor Standards Act of 1938, FLSA, requires employers to pay minimum wage and overtime, if applicable, to eligible employees. But these legal rights do not apply to independent contractors. For a while now, there hasn't been much clarity from the federal government on how employers and courts should classify workers within the FLSA context. This has led to multiple rules and tests across the country. But on September 25, 2020, the U.S. Department of Labor (DOL) published a new proposed rule that outlines a test for classifying workers under the FLSA. Historical background of FLSA worker classification: back in 2015, the DOL issued an administrator's interpretation (AI) as to how the DOL believes workers should be classified under the FLSA. The AI took an employee-friendly approach and stated that courts should use an economic realities test. This test would emphasize the questions of whether a worker is in business for himself or herself, or if the worker is economically dependent on the employer. Additionally, the AI reflected the DOL's belief that courts should take a broader view of who is an employee under the FLSA. The economic realities test would examine the following 6 factors. When answering these questions, the AI indicated that neither would have special importance. The 2015 AI emphasized that the control factor would not play a special role in deciding if a worker is an employee or independent contractor. Instead, all the factors should be looked at equally to determine the extent of the economic dependence the employee has with the employer. The more economically dependent the worker is on the employer, the more likely they would be classified as an employee. In 2017, the DOL withdrew the 2015 AI, but did not issue any replacement rule, regulation or guidance until September 2020. DOL's proposed rule concerning independent contractor status under the FLSA. The DOL published its independent contractor status under the Fair Labor Standards Act proposed rule on September 25, 2020, and it contains the following 5-factor test. In some ways, the DOL's September 25, 2020 proposed rule is similar to the 2015 AI because many of the factors are the same. But simply comparing the factors side by side doesn't reflect why the proposed rule is more likely to find that a worker is an independent contractor as opposed to an employee. For example, the proposed rule places special weight on 2 core factors: nature and degree of control over the worker's work and the opportunity for profit or loss.